Hello, Internet. It's Daniel, Driving and Dragons. And we are back into the drama mill of the tabletop role-playing game space. I'm going to make this one quick as I can because it's really just stupid. But the only reason I really bring it up is because it's the kind of thing that keeps cropping back up from some common misunderstandings. So we're going to knock this out, and then I'm going to do a video on world building to kind of go with it so that we get some real gaming content this week while we're at it. The Z got some throttle body cleaning going on in the video today, just continuing to work on airflow and just engine maintenance and stuff while I'm waiting on some parts for the distributor, because older cars, sometimes it's difficult to get the parts, and I'm pretty sure I have to replace this entire distributor, being a real bitch to get the thing apart. But hopefully we'll have that up and they'll fire on up and we'll be ready to rock and roll. Okay, so what are we talking about today? Mainly we're going to talk about IP, and it really relates back to Harmony Ginger and this nonsense that is going on with the expression Braunstein gaming as a style of play. It's a particular way to play the game. The Bro SR really is involved with it. From what I understand, that's actually where the term Bro SR comes from. It doesn't actually come from like bro, like they're bros who play role-playing games or old-school role-playing games. They are Braunstein style. That's where the BR in Bro SR comes from. I don't know if that's 100% true, but that is definitely one description that I heard. And it fits because they tend to be very aggressive about a very specific style of play that fits in with that Braunstein style. Braunstein comes from a gentleman by the name of David Wesley. And basically what happened is Harmony comes out and starts describing her game as Braunstein style or using Braunstein gaming rules, which is accurate in the way you're supposed to say it. And you got a couple of guys, predominantly Griffith Morgan over at the who did Secrets of Blackmore, and a couple others who have decided to come out and just make complete fools and asses of themselves, threatening legal action over the term Braunstein, as if this is somehow an infringement of IP. And by all marks, it really isn't, and there's no evidence that it is. But this is a common tactic. It happens a lot. You see major corporations do it. As a matter of fact, Wizards of the Coast very famously did this. And when I say they very famously did this, the entire OGL situation is a non-starter. There is settled case law specifically related to Dungeons & Dragons, and even more so going all the way back to a Supreme Court decision that I believe was sometime in the early 1900s, that essentially states that you cannot copyright, trademark, or patent specific play styles. You can copyright, trademark, and to a lesser extent patent certain things within the game, but the mechanics themselves, you can't do that. Your actual terminology, such as calling it a Braunstein game, would actually be something that could be potentially protected, albeit it'd be a relatively weak protection. But what you really have here is the same thing that what the OGL really did. The OGL did not give open license to everybody to do stuff. The open gaming license was simply a promise that had legal weight to it that said that Wizards of the Coast was not going to sue you over your use of 3rd edition Dungeons & Dragons rules, and saying things were compatible, etc., with the D20 system. Basically, if they tried to bring any form of legal action against you, all you or your attorney would have to do is submit the open gaming license from your whatever material you put out, your adventure or whatever, and that would be it. Bang the gavel, this is dismissed. There's an agreement right here that flat out says as long as you do certain things, we won't pursue any action. You're proactively granting permission. And it has nothing to do with actually granting permission. You don't need that permission because it's not protectable content. However, anybody who knows anything about IP law, particularly in the United States, knows that the barrier to entry, the minimum, the cover price to get in the club of IP litigation is about 30 grand. It's going to cost you somewhere in the neighborhood of $30,000 in filing fees, lawyer fees, research fees, etc., just to get your IP case in front of a judge. That's just the That's just how it works. These are federal cases. It's done in federal court, which is extraordinarily expensive, and it's a very, very specialized section of the law. Because of that, the threat by itself is 9 times out of 10 enough to shut somebody down. Because when Wizards of the Coast shows up on your door and says, we're about to take you to court over trademarks or copyright related to Dungeons and Dragons, and you say, well, you don't have a case, they'll say, well, that's fine, but it's going to cost you $30,000 to prove it. Do you have the $30,000? No. So they basically bully you with a more potent war chest in their army of lawyers. What does that have to do with it? Because that's what these guys are trying to do to Harmony Ginger and to with the whole Braunstein fiasco. Basically coming out and saying, sending in emails and stuff saying that they're going to pursue legal action, and not even legal action on behalf of their own IP, but on behalf of somebody else who they're trying to keep out. So I'm going to go ahead and read this real quick. Just, this is tweeted out. It was an email that was sent to Harmony Ginger. Blackmore is the only campaign to have utilized all 4 RPG formats in one game as far as I know. I just got off the phone with David Wesley. If you won't listen to me, then maybe you will listen to what he has to say. David is really adamant about protecting his game rights. He proceeded to tell me the story about a man who invented the Colt repeater. As the story goes, Colt sent letters to all of his competitors and said, I'm too poor right now to sue you for any infringements on my patents, but as soon as I can afford it, I will be coming for you. 15 years later, Colt had enough profits from the design that he proceeded to sue all his competitors out of business. On the flip side of that is how David is very amicable to anyone wanting to license Braunstein for a nominal sum in order to create Braunstein-adjacent products selling through use of the Braunstein label. You may contact the Fellowship of the Thing Ltd. For licensing inquiries. Additionally, David Wesley is not accepting interviews until further notice, or till the drama dies down and we can just all get along. Ciao, Griff. So basically, this is saying, hey, I'm going to come after you and sue you, and oh, look what Colt did. And it's kind of funny because Colt actually had something that would be an enforceable patent. All right, that's just all there is to it. This is not. So let's start off with 3 very broad, very high-level views of what protected IP is. A patent is a protection on a proprietary practice or proprietary use or mechanism. And the reason why patents really exist is because putting out how the device works is seen as a public good for people to develop and people to work on. So in order to get a patent, you actually have to put forth all of your own research, all of your own design and everything, so you can show how it's unique and show how it does what it does. But the patent gives you a limited amount of time that you have a right to actually use it just by yourself, so that you can make profit off of your idea before it becomes public domain, since you have to show everybody how the cake is baked, so to speak. Copyright is a different type of IP. That is inherent to you creating an actual work. Now, you have to create the work. You have to record it either in a video medium, you have to put it down in some artistic expression, you have to write it, you have to sing it, you have to actually produce it in order to have copyright. You can't just have an idea in your head that you say is unique. It has to have been done in some form for you to have copyright. And here's the thing, copyright is the only IP that is inherent. In other words, you don't have to file anything for it. You don't have to put any kind of a notice with the government. There's ways you can register it in order to kind of strengthen it a little bit, just to kind of say, here's the proof that I was first, without having to go through as much legal wrangling to do so. But in all honesty, if I paint a painting right now and you copy that painting, I already have the copyright on it. You sell it, I can come after you. You present it as yours, I can come after you. However, that has to do with, copyright's a pretty narrow focus. It has to do with unique artistic expression, and Braunstein Gaming is not that. It really isn't. It's not something that could stand up to a copyright. It could potentially be patented. However, even that is a little iffy, because at its core, Braunstein is based on the mechanics of an IP that they don't own. It's based off of Dungeons and Dragons. So you can't, oh, this is my method of playing somebody else's IP. And finally, you have trademark. And trademark, people confuse trademark and IP, or trademark and copyright all the time. They confuse trademark and patent all the time. Trademark is exactly what it sounds like. It is you are putting a specific protection against you using something in a specific trade. All right, it is isolated to the trade. So in this case, it would be isolated to gaming, tabletop gaming, etc. It would not protect, say, the use of Braunstein in terms of if I wanted to make a car company called the Braunstein Car Company and wanted to use Braunstein in my trade advertisements and my marketing, it wouldn't infringe a trademark granted to Braunstein as a gaming term, predominantly because I'm using it in a different trade. I'm not trading on their good name and everything because I don't operate in that space. This is also part of the reason why you'll see things where there are hundreds and thousands of trademarks on the same thing, because a company that is big enough that has multiple interests is trademarking the same thing in multiple different ways across multiple different industries and trades to make sure they cover all their bases. But one of the key elements of trademark law is that there has to be a reasonable expectation of confusion to the client. And nobody thinks that Braunstein Gaming has anything to do with Braunstein Automobiles. They're not the same. So the thing about a trademark or a patent, and these are the two that are most important, is that they have to be registered. They have to be awarded by the government with a challenge period and all kinds of other stuff. And I've gone on here to the USPTO website, and I have done searches, and I have gone through many, many, many pages of Braunstein and other related trademarks. I've looked under David Wesley. I've looked under Griffith Moore. I've looked under these for anything that's related to this particular beef. And the fact of the matter is that it's not there. Oh, it's just not there. There's no registered trademarks. There's no registered anything else there. As a matter of fact, even when I look for the actual company that he produced, the Fellowship of the Thing, I'm not even seeing the Fellowship of the Thing Ltd. as a live trademark at all on the USPTO website. It's not live. It's not there. Maybe I missed it there, but even the company that he is calling, saying that this is the thing that owns this site, that owns this trademark, doesn't appear to be an actual... there's a company, it's a limited liability company, but the only thing, Arnicon is the only thing that it actually has any trademark to, and it has the trademark over the font and particular style and name of putting Arnicon in the use of the field of gaming. It doesn't say anything about Braunstein. It doesn't have anything to do with any kind of gaming style. So there's nothing here for the basis for anything. This is just a threat over people using a common descriptor for a particular type of play. And it's stupid. This is the kind of thing that is just really, really foolish. Because let's just say that what he's really doing, because from everything I've heard and what I've read, the problem is that he is somehow, the guy who did Secrets of Blackmore is in some way trying to market off of the name Braunstein. He's asserting that he has exclusive rights to the term and is using it for products and discussions and projects and so on and so forth for future endeavors. This would do nothing but help him. If he had half a brain, somebody getting more people interested in that style of play while not trying to even produce any kind of competing product or any kind of competing element is good for him. And he's really kind of overplayed his hand in this because he's putting out here that I've got this, I'm going to make this attack, I'm going to do this thing. He better hope that nobody has some kind of Braunstein game idea, or just goes out and makes Braunstein Gaming LLC or something and slaps that trademark on it before he gets to it, because I hate to tell you, buddy, these things are first come, first serve, and it is really, really difficult to get the Patent and Trademark Office to overturn somebody's trademark after the fact, unless you just got a substantial amount of evidence that you were trading on that IP ahead of them in an exclusive and unique manner. So, like I said, he's really tipped his hand. He better hope nobody jumps on the USPTO website right now, pays a couple $100 filing fee, and gets themselves a 7-year trademark on Braunstein as it relates to tabletop gaming. And now he's really screwed because he decided he wanted to run around trying to wave his pecker at people and play Mr. Big Balls to try and intimidate people into not using a word. It's the dumbest kind of thing you've ever seen in your life. Now somebody could probably slip in behind him, nab that trademark, and I don't care if David Wesley comes out, I don't care who comes out with it, they're not going to have a leg to stand on, because none of this stuff is registered as far as I can tell, and I spent hours digging through the USPTO webpage, just doing every kind of search term you can think of to find where he has some sort of registered IP for Braunstein Gaming. You're talking about something, in short, that really cannot be patented. As a matter of fact, it's not even really cannot be patented. It cannot be patented because the Supreme Court of the United States has already stepped up and said that you cannot put a patent on game mechanic. That's why we can roll dice, okay? Dungeons and Dragons, TSR, and then eventually Wizards of the Coast could have come out and said rolling dice to determine outcomes is our mechanic, and could have put that patent on it. Except they can't, because that's protected. All right, it's not protected by IP law, it's protected by that Supreme Court decision. So the Braunstein gaming style or play style, the Bro SR playing style here, is not going to be something that you can have a sustainable patent on. And as far as I can tell, there's absolutely no trademarks registered on it either. So you got a guy who just put a target on his back and has a big opening in his guard, and is probably borderline open himself up to a harassment, if not a defamation countersuit, if he decides to pursue this kind of nonsense, which is probably why he went back to Harmony later and said, oh, well, I'm going to give my apologies, and here's my apology. But even then, he wanted to put conditions on his apology. Conditions about, you can't use this and you stop using that, and et cetera, et cetera, et cetera. It's just the dumbest stuff I've ever seen. And it never ceases to amaze me. I keep trying to move away from tabletop role-playing game drama, and yet here we are again. More drama with no real basis to it, which is just people pissing in each other's Wheaties, and more of the good old-fashioned bucket crab mentality. Why do you care that people call it Braunstein? If you want to make something and trade on Braunstein, make it, put it out there, register for the trademark, see if it sticks, then you can turn around and you can say, hey, don't use this in trade. Okay, don't trade on this. Don't try to make money off of it. Which, by the way, that is one of the big differences between trademark and copyright, is that you have to have reasonable confusion. There has to be use in trade and whatnot on a trademark, whereas on copyright, you just can't copy. But this is not a copyright matter. You definitely can't copyright the word Braunstein, because Braunstein is the name of an actual town in Germany, if I'm not mistaken. You can't do that. It's not something that could have a sustainable copyright. And you're not going to get a patent on it because it's not something that can be patented per the U.S. Supreme Court, and you don't have the trademarks on it, and I'm not even sure the trademarks would stand up. I don't think there's necessarily enough there as it sits. So this is another one we just need to let go. If somebody enjoys the style of play that you want to make a product for, you really ought to be kissing their ass for putting out more and more and more awareness, so that when your product is actually ready to hit the market, it's got buzz around it. Instead, all you're doing is pissing off every potential client you have, and they'll not buy your shit just out of spite for the way you've behaved. But anyway, that's all I've got. I'll see you guys next time. Like, share, subscribe, and be on the lookout for a video about world building that's coming up here in the future.